Welcome, I am the loud little ducky. Today we have the reply brief by Owens in the Owens v. Eckerd appellate case. Owens is appealing her loss against Clayton Eckerd in the bachelor paternity scandal that she has created and her attorney has just set on fire. Let's get into it. Court of Appeals, State of Arizona, Division 2. Laura Owens, petitioner appellant versus Clayton Eckerd, respondent and appellee. It was originally Maricopa County Superior Court with Judge Julie Mata. Appellant's reply brief, and it has Gingras' info for his law office. Table of Contents is the preface, the discussion. Of course, Rule 26, because he's all about Rule 26. Issue 2 is structural error. Issues 3 and 4, the court erred by awarding fees under other authority. And issue 5, Laura is entitled to fees. And then he has his conclusion. He has his table of authorities, so all the cases he's relying on, as well as the rules and statutes that he is relying on. Preface. Like any appeal, the primary focus should be, did the lower court commit any reversible legal errors? Sometimes the answer to that question depends heavily on factual issue and sometimes not. The case involved complicated facts, and without a doubt, the record reflects numerous factual errors committed by the trial court. Indeed, the very first fact the trial court found that Laura commenced this action on May 20th, 2023 was wrong. See footnote 1. The case was filed on August 1st, 2023, not May 20th, 2023. No, May 20th was the date of her alleged conception and the night that Clayton says he had oral, which usually does not equal babies. But the trial court's minor mistake as to the filing date is not why we are here. Laura's opening brief made that clear. Plentiful and egregious factual mistakes, notwithstanding factual errors, are not the primary focus here. Opening brief, also known OB at 2. The statement was and is still true. So I think he put this in here as a way to kind of be like, this is a harmless error. Which I just saw that was the name of his freaking YouTube channel. He just likes to mock. And sadly, he's the butt of the jokes. Every time. Along with his client. At the same time, it is critically important for this court to receive accurate, underlined, information about the facts to help guide the court's legal analysis. Unfortunately, Clayton's answering brief contains inaccurate statements about the record, some of which are highly inflammatory. Laura's reply thus begins with some clarifying points to avoid confusion about the record. Laura's opening brief explained the trial court made multiple errors of fact. Many of the trial court's findings are either directly contrary to the admitted evidence and supported by no evidence of any kind. And he cites the opening brief and emphasis added. Despite this warning, which was not news to either side, in his discussion of the facts, Clayton repeats numerous findings made by the trial court as if they are accurate and supported by the record, even when they plainly are not. A few of the more serious examples. Laura admitted sending Clayton a sonogram video she copied from YouTube. Clayton claims Laura admitted to providing Clayton a 7-year-old sonogram video of twins she obtained online months earlier. AB 39. As support, Clayton cites the under advisement ruling, and sure enough, it does contain that finding. What do you know? The JFC cult, as he calls it, even though we are not a cult, was right. But he can't ever give us that credit. And so it says petitioner provided respondent with sonogram that was posted on YouTube 7 years ago. Petitioner admitted to this during her deposition. The UAR states Laura admitted to this during her deposition. The UAR cites trial exhibit A2 as support, but that exhibit was not admitted into evidence, and it was not Laura's deposition. It wasn't the deposition. It was the order of harassment or her order of protection hearing, or his injunction against harassment hearing. He asked her flat out, "Did you send me this?" And she's like, "Yes, but like that's not the video I sent you. Like I had a different video to send. But yeah, it was from me." But in her mind, it was Greg who hacked it and actually sent it to Clayton on behalf of Laura, pretending to be Laura, which is a load of crap. Worse yet, in her deposition, which was received in evidence as trial exhibit B49, Laura did not admit to sending Clayton a sonogram video from YouTube. On the contrary, Laura flatly denied this allegation. Okay, so he admits she did say it somewhere, just not these places. So you're still admitting that your client is a liar. But yet there was just no reason that Judge Mata could have found that her stuff was unreasonable. So she said she did, then she lied again and again. Your client has credibility problems, Gingras. So let's read this, and we're going to start from the beginning just because we don't get a lot of the deposition stuff. It says, if you pull up your sent account and you looked at October 6, 2023 in an email exchange with Clayton, and by the way, there is other emails on this chain and we are going to get to them, and you saw in your sent account that you attached this witness or attached this ultrasound image, you would agree you sent it then, correct? I am positive I did not send this ultrasound video. This is not. So that's how we know it wasn't like Greg hacking, is because if it was Greg hacking, that email would be a completely separate email, in my opinion. It wouldn't just be a random email, like a reply to an email on an email chain between Laura and Clayton already happening. So it's like Laura sends something, Clayton replies, Laura sends something else in reply to that reply, and then so on. And so this video was sent in that chain. But of course, that was Greg in Dingus World. And so then we have Laura gave exactly the same response at trial. Question. Laura, exhibit. Clayton's exhibit 31 it appears to be an email from you to Clayton. It says ultrasound video proof. Clayton, here's my 100 billion% real ultrasound video. Do you recognize that? It's not an email that I sent, but I've seen it. I bet you have. In short, there is not a shred of evidence in the record to show that Laura admitted sending a sonogram video copied from YouTube. She sent that video, and she knew what that video was. It is false to say Laura admitted this in her deposition. On the contrary, Laura denied this in her deposition and denied it again at trial. Laura knew she was not pregnant when she filed this action because she did not allege sexual intercourse occurred in her original petition. One of Clayton's central themes is that Laura knew she was not pregnant because only oral sex occurred. Clayton's brief repeats that story. On May 20th, 2023, Laura performed oral sex on Clayton. In a footnote to that sentence, Clayton further suggests Laura alleged there was non-consensual sexual intercourse, but this was not alleged initially in the court filings. It was not alleged until 2024. Emphasis added. Laura's original petition conclusively disproves this. See footnote 2. There was a separate dispute as to whether the intercourse was consensual, but Clayton does not frame the issue as limited to that question. Moreover, the alleged lack of consent was not new and was not raised only after Clayton sought sanctions. It was described in a correspondence with the parties shortly after the case began. Email from Laura sent October 14th, 2023. Yeah, that was after things. That was still after. And then so he shows here that she did check sexual intercourse. Parties A and B were not living together and had sexual intercourse at the probable dates of conception of the minor children. The mother of the minor children did not have sexual intercourse with anyone else during the periods in which the minor children could have been conceived. No, the ARPing allegations came later. But I guess she did that, which if they're going to be making arguments, they can't be making mistakes because Gingras is going to call him out because he's got to take the wins where he can get them. And if this particular thing is stated wrong, it should be corrected. Like, we've got to be dotting our I's and crossing our T's with these things. Laura does admit she sent that email with that video in the injunction against harassment hearing in front of Judge Duty. Okay, it wasn't in the deposition. She still admitted she sent it, and then she tried to blame it on Greg. If she checked this box, great. The thing is she did not allege the ARPing in her original petition. Multiple other men believe Laura fabricated pregnancies and doctored medical records. One of the most harrowing examples of an inflammatory yet baseless fact offered by Clayton is this. This was set the fourth time Laura had tested positive for pregnancy in her lifetime. All prior alleged fathers believe she fabricated the pregnancies and doctored medical records. To support this shocking fact, Clayton quotes from the URA, and once again, page 4 contains those exact findings. What admitted trial evidence supported that finding? Absolutely nothing. Due to the extreme brevity of June 10th evidentiary hearing, no other prior alleged fathers testified, just Clayton, nor was their testimony offered by others means stipulated or deposition. In fact, the only attempt to support this allegation was a question that led to an objection that was sustained. It says question, and they also believe that you doctored medical records, right? Gingras object, foundation. The court sustained the objection because foundation hadn't been laid for that. But the thing is, if you listen to the very end, Judge Mata says she will take this and all filings into consideration and issue her ruling. The men, the prior alleged fathers, and their statements about fabricated pregnancies are in those previous filings. She took the whole case under advisement in ruling this. She didn't just rule on the evidentiary hearing. She ruled on everything that had happened in this case. He seems to keep missing that she was allowed to consider all previous motions, which is where the independent investigation was given permission because his blog was cited, which let Judge Mata click on Gingras' blog because it's now in a motion and in a court document to go look at as evidence in this case. Woodnick made sure to enter Gingras' blog into this case in a motion. That is where the alleged fabrications of pregnancies by other men is. That is where the sonograms that Laura has done things with are at, or is in those previous motions. Some of them were brought up at the evidentiary hearing, but some of them are just in the motions and filings in this case as a whole. So everything from August 1st through June 10th is what Judge Mata considered when giving her ruling on this case. And I am so tired that Gingras keeps forgetting that everything was not based on June 10th. And if that's how it should be, then I am mistaken. But according to the judge's rule, or what she said, was she was taking everything that has been filed under advisement and issuing a ruling. Somebody correct me if I am wrong about this in the comments, please, because it irritates me. I am not a lawyer, but that is my understanding. The above examples are only a few instances of several inaccurate statements Clayton makes about the record below. To be clear about actual facts in the record, Laura did not admit sending someone else's sonogram video copied from YouTube in her deposition or anywhere else. Laura did not file this paternity action without alleging sexual intercourse occurred or alleging that only oral occurred, and there was zero admitted trial evidence to show either that Laura fabricated a pregnancy in the past or that other putative fathers believed she doctored medical records. Of course, Laura recognizes the trial court found the above points were true, and she understands factual findings normally receive deference, except where, as here, they are clearly erroneous. Gibbs v. Gibbs, Arizona Appellate Court 2011. It suffices to say the trial court's factual errors are extensive and Clayton's discussion of the facts is misleading at best. But there is good news. Resolving this appeal does not require reversing the trial court's factual errors. As such, this brief does not identify or explain every factual error, because factual disputes have no effect on this appeal. This court should not linger on them. It should just be aware Laura firmly disputes the accuracy of the record as discussed in Clayton's brief. Discussion. Turning to the merits, we begin with the subtle theme in Clayton's brief. While he never specifically says so, his position rests heavily on the old maximum. Equality will not suffer a wrong without a remedy. And it cites a case that's appellate 2013. Clayton argues Laura's position is inequitable because, in his view, the core issue is whether a person may tamper with evidence and lie under oath, and then opt out of the litigation consequence-free. He has emphasis added in a appeal brief or something, I'm guessing was at AB. If ever there was a histrionic argument invoking the all-flexible power of equity, that's it. But Clayton is wrong to suggest that Laura will walk away consequence-free, in quotations, air quotes, if she prevails here. Putting aside the devastating reputational, emotional, and financial harm she has already suffered, putting aside the reputational, emotional, and financial harm she has caused herself is what that should say. In addition to the nearly $150,000 judgment. No, $150,000 awarded of attorney's fees. She's just being ordered to pay attorney's fees and costs. That's it. The trial court also referred Laura to investigation and potential criminal prosecution, as she should. She should. But if they don't do anything with that, she just gets to walk free if Rachel Mitchell doesn't do what she should do. The Maricopa County attorney has not yet charged Laura with any crime, despite making public statements about her investigation. Yeah, looks real good for the appellate people to know. Yeah, she was referred for prosecution, and the Maricopa County attorney hasn't charged her, but they have made public statements about her being investigated. Like, looks real good. They're really going to want to help her out. It's impossible to know why charges have not been filed. Whatever the reason, Clayton is wrong to say if Laura prevails, she will walk away without any consequences. Hardly. Well, you should face consequences for your actions. If you have bad actions, there are consequences. Fuck around and find out. That's what Laura's doing. She has fucked around for too long. Literally. And now she's finding out. Clayton also ignores another point. Even assuming this court orders the paternity case dismissed and does not mean Clayton has no remedy. Indeed, while Clayton argues Arizona Civil Rule 11 and Family Law 26 are materially different, i.e. less protective of litigants like Laura, than the federal version on which they are based, the comments to the 1993 revision of Federal Rule Civil Procedure 11 are clear. The rules safe harbor. Except for nobody gives a shit about the safe harbor except for y'all. Safe harbor left the dock. There's no safe harbor. The boat left. With Rule 26, it left. It's no longer at the dock. Does not provide immunity from civil liberty arising from litigation abuse. It should be noted that Rule 11 does not preclude a party from initiating an independent action for malicious prosecution or abuse of the process. Trust me, you don't want Clayton to file a lawsuit for defamation, malicious prosecution, abuse of process, because it's going to cost her a lot more than $150,000. I can tell you that right now. She might owe $1 million for the shit she has pulled. And it might be a class action lawsuit. I don't know how many people it takes to do class action, but it could be. Round up the last 10 years of victims. Let's go. If Laura wins this appeal, Clayton could potentially still bring a separate civil action against her. While this option exists, it may be a bad idea. Probably not. Clayton's trial counsel used a similar approach in an earlier case and lost. And then he cites a footnote, and it's just record of appeals stuff. Nevertheless, if Clayton wants more relief, other options exist. Except for before, nobody wanted to listen. And now, the amount of stuff that even Greg Gillespie has that he didn't have back then, she's in for a different ride with this one. This leads to the final point that is extremely important. I doubt it, because nothing you say is important. It is clear what really happened in this case below. Clayton tried to litigate civil tort counterclaims against Laura in family court, but he forgot one key thing. The family court has no subject matter jurisdiction over tort claims. No, he is punishing her in a paternity suit that she filed falsely. And a paternity suit falls within the family court jurisdiction. This is so because although Arizona family court sits in equity, their jurisdiction is strictly defined and constrained by statute. Despite the application of equitable standards in a dissolution proceeding, it remains statutory action, and the trial court has only such jurisdiction as is granted by the statute. Thus, Title 25 defines the boundaries of dissolution court's jurisdiction, and the court may not exceed its jurisdiction even when exercising its equitable powers. I am so glad you cite 25 because there is a lot of things in that 25 that Clayton has on his side and that Judge Mata used in her ruling. 25. 2-5, not 2-6. Because 2-6 left the harbor. It was no longer safe for it to be at the dock. So 26 left out to sea and is bye-bye. C'est la vie. He cites a case, I think it's Weaver v. Weaver, 1982, giving family court limited jurisdiction to establish maternity or paternity. Well, we did that here. With little to no fetal DNA, it did not meet the threshold for Clayton to be the father of any babies, fictional or not. Once Laura informed the family court on December 28, 2023, that she was no longer pregnant, there was no paternity to establish. Nothing in Title 25 authorized the family court to exceed its limited jurisdiction by granting Clayton limitless, freewheeling power to endlessly investigate and litigate civil tort claims in family court. Those claims belong in civil, not family court. In any case, Clayton is simply wrong to suggest Laura winning this appeal means she walks away consequence-free. The thing is Clayton did not get awarded anything but his attorney's fees and costs for her bringing this case and lying about a bunch of shit. Like, he thinks like this might stand if she had had to pay attorney's fees and got sanctions on top of those attorney's fees and all of this stuff. But all she was required to pay was the attorney's fees. He didn't get awarded anything else. That's why I don't think there's a lot of merit to a bunch of this stuff. They both asked for attorney's fees. She asks for attorney's fees here. It's not like some big thing. They just piled on all this money on top of her that's just so awful. It's just attorney's fees. Yeah, it's a lot, but don't pull this shit. If you would have just behaved like a normal person, you would have probably gotten to walk away and both parties would just have to be responsible for their own attorney's fees and nothing else. But you didn't behave properly. Issue 1, Rule 26. Yay! Laura's brief presented 5 questions for review. Clayton's response breaks each into multiple subparts. This reply will follow in a similar format. Laura was sanctioned under Rule 26, but even if she was not, the safe harbor still protects her. Clayton begins by challenging the centerpiece of Laura's arguments, i.e., that Clayton did not follow the requirements of Family Law Rule 26, so the award of sanctions under Rule 26 was improper. There was no award under Rule 26. Clayton says this argument is misplaced because he thinks the trial court did not sanction Laura under Rule 26, which she didn't. Nowhere in the final ruling does it say, I am issuing this under Rule 26. Does not say that. Therefore, Clayton contends Laura's arguments about Rule 26 are moot. Yes. Clayton's rebuttal echoes René Magritte's famous surrealist painting, The Treachery of Images. To make a point, Magritte absurdly painted a smoking pipe. The caption, the painting with a famous line, "Si en es pas un pipe." This is not a pipe. It's a painting of a pipe with a caption that reads, "This is not a pipe." Get it? Yeah. This ruling is not Rule 26, but you keep saying it's Rule 26. Do you get it? I don't think so. Much like Marguerite's painting, Clayton's Rule 26 argument is equal parts surreal and absurd. You are absurd, sir. Of course, the trial court sanctioned Laura under Rule 26, putting aside the fact that Clayton filed only a Rule 26 motion for sanctions and no other motions for fees or sanctions. Every single filing that Clayton has made has asked for attorney's fees. If you go and look at Clayton's first time ever saying anything in the court, because we have August 1st, we have initial parenting plan, order and notice attended parent information program class, and the summons, along with the complaint and affidavit of service. Okay? All those were August 1st. August 21st, 2023, Clayton's first time talking about this case or submitting anything to the court. In his response to petition to establish paternity, it's like handwritten out and everything like that. He asks for things under Title 25. He also asks for attorney's fees and costs. In the motion, his first motion or response that he ever filed in this case, he was pro se. He asked for fees and I guess sanctions, if you want to call them the Title 25 sanctions. He asked for those things. So the fact that he sits here and states no other motions for fees and sanctions is BS. And he talks about, oh, this person lied to the appeals about facts. Sir, you just lied. You're a hypocrite. But yeah, that was before your time, right? You don't know anything about Clayton's first response in this case. Too far back. Because you're a shitty lawyer, in my opinion. The UAR specifically cited 26 as a proper basis for sanction. Furthermore, the June 10th hearing was set in response to Clayton's Rule 26 motion. 2-1-24, setting evidentiary hearing regarding the issue of sanctions and attorney's fees. I'm not going to tap my mic, but sanctions and well, that didn't do what I wanted it to do at all. Let's do that again. Jeez Louise. And attorney's fees. Look at that. And guess what? She was only awarded attorney's fees. Amazing. I know. You're welcome, guys. At the time the evidentiary hearing was set, Clayton's Rule 26 motion was the only pending motion in which sanctions or fees were requested. No, it was not. Like, I don't want to make a video of the request for sanctions or fees or anything like that. I don't want to make a video of the last page of things every time it's been asked, but this is not true. This is just a flat lie. Laura has noted many times the rules of family law procedure require parties seek relief to bring a motion for relief. You don't have to apply, you don't have to ask, you don't have to send a separate motion to be like, hey, this is a motion for attorney's fees. Like, you don't have to do that. It's asked and it's brought up and it's talked about and it was granted. Arizona Rules of Family Law Procedure 35A1 explaining a party must request a court order in a pending action by motion unless otherwise provided by the rules. Expressing a desire for fees in a response to a petition or verbally at a hearing is not sufficient. A motion is required, yet the only fee-seeking motion Clayton ever filed sought fees only based on Rule 26. This is just a bunch of lies. We just have to listen to them. Since Clayton brought a motion for sanctions under Rule 26 and did not bring any motions for fees under any other authority, the trial court must have granted relief under 26 based on the court's own authority, precisely as a UAR states it did. The noting the power is thereby rule and can't be used by the court when necessary and appropriate, emphasis added. A painting of a pipe is still a pipe, no matter the caption, and an order granting sanctions under Rule 26 is a Rule 26 order. The question of whether the award was proper under Rule 26 is hardly moot. Maybe in your mind, and it will be so nice when this crap gets laid to rest and the appellate court tells him to fuck off, basically. Like, this is ridiculous and egregious. And he should have to pay the appellate courts for even having to listen to this. Obviously, hoping to sidestep this landmine, Clayton shrugs his shoulders and suggests the lengthy Rule 26 analysis in the UAR does not actually mean Rule 26 was invoked. Like Marguerite, Clayton points to an unmistakable painting of a pipe and proclaims that's no pipe. No. According to Clayton, the court's lengthy discussion of Rule 26 was purely illusion, fluff, academic surplusage, and nothing more. Yeah, it is an illusion and fluff. And tomfoolery. The court included details, findings about Rule 26 issue in the UAR, but the court ultimately only awarded attorney's fees and costs under Title 25 statutes based on relative financial positions, unreasonable positions, and discovery and disclosure violations. Or did it? Ignoring that the court did rely on Rule 26, even if it did not, there are three other significant problems with Clayton's argument. No, there's many problems with your arguments. First, contrary to Clayton's suggestion, the court declined to award fees based on relative financial positions. On that, the UAR was ambiguous. The court finds there is no substantial disparity of financial resources between the parties. Second, Clayton is correct that the court based its decision in part on unreasonable positions. But what unreasonable position did Laura take? Okay, we don't have all day to be listing them. We've said them 1,000 times. She lies. She tampers with evidence. She just needs to be stopped. Again, the UAR leaves no doubt. The court further finds that petitioner acted unreasonable in the litigation. Specifically, petitioner acted unreasonable when she initiated litigation without basis or merit. And then he cites, with emphasis added, so, per the court, Laura's unreasonable position was the same Rule 26 violation raised in Clayton's Rule 26 motion. This time, the painting and caption say the same thing. This is a pipe. I can tell you where to put that pipe, Gingras. This leads to the third and perhaps biggest problem with Clayton's argument. It ultimately does not matter whether fees were awarded under Rule 26 or some other authority, such as the court's inherent authority. That was precisely the point of cases cited in Laura's opening brief, like Radcliffe v. Rainbow Construction, 9th Circuit, 2001. Radcliffe held the safe harbor of Rule 11/26 protects litigants from life-changing sanctions when they are accused of litigation misconduct. The rule gives accused wrongdoers a safe harbor to correct or stop the alleged violation and thereby escape sanctions. She didn't get sanctions, she got attorney's fees. Barber v. Miller, 9th Circuit, 1998. A safe harbor that offers protection from sanctions under one legal authority while offering no shelter from sanctions or the identical conduct under a different legal authority is no safe harbor at all. As the 9th Circuit explained in Radcliffe, to ensure the law works as intended, the safe harbor cannot grant partial safety. Otherwise, it's just a screen door on a submarine. Yeah, the submarine left the harbor too. For that reason, a court cannot fix a defective motion by awarding sanctions sua sponte, precisely as happened here. It would render Rule 11C1A's safe harbor provision meaningless to permanent parties' non-compliant motion to be converted automatically into a court-initiated motion, thereby escaping the service requirement. Radcliffe. And he says, yet that is exactly what happened here. The court is free, of course, to disagree with the 9th Circuit's decision in Radcliffe. On page 25 of his response, Clayton argues for that result. In support, Clayton cites dicta from cases like some other case, which is an 8th Circuit 2024 case. But on a closer inspection, That case supports Laura's position, not Clayton's. We'll see. Word cannot pronounce. Involved a vexatious litigant who filed multiple lawsuits trying to avoid foreclosure on her home. In the fourth such case, Miss Carancini, well, we tried to pronounce it, was represented by attorney Gregory Lay. One of the defendants, a trustee named Martin Leah, was dismissed from the case for reasons not explained in the decision. Okay. 2 months after Mr. Leah was dismissed from the case, he served with a draft Rule 11 motion and a letter warning that the motion would be filed with the district court after 30 days, unless the issue was resolved to the firm's satisfaction. Of course, by that point, Mr. Carancini's claims against Mr. Leah had already been dismissed, leaving her way to withdraw or correct the alleged Rule 11 violation. The violation was an unfixable fait accompli. Mr. Leah's Rule 11 motion was filed. The court granted it and awarded $107,710.10 and fees, plus an additional $50,000 penalty. The outcome of the Carancini is thus extremely similar to this case. As this court should do, the Court of Appeals reversed. Indeed, despite finding the underlying action was frivolous and filed in bad faith, the Court of Appeals held the sanctions award was improper. Yes, the sanctions award. But were attorney's fees a reversible error? And this part is key. The award was improper because it was imposed in a manner that deprived Mr. Lay of any chance to take the safe harbor. This part should sound very familiar. Yes, it sounds very familiar from you, but I don't think that is not the thing in this case. Here, Martin Leah served its motion for sanctions on October 5th, 2018, on my birthday, a month and a half after it had been dismissed from the case. Thus, Attorney Lay was not afforded an opportunity to remedy the sanctionable conduct and avoid the sanctions. The district court speculated that even if Lay had been given the opportunity, he would not have dismissed the claims, given his colorable record in this case. But assumptions do not excuse compliance with the text of Rule 11. Therefore, the imposition of Rule 11 sanctions against Lay cannot be sustained. Emphasis added. In dicta, the court strongly condemned Mr. Lay's conduct in the filing the frivolous action. In that criticism, the court offered closing comments, which Clayton cites as support for his position. The tactics employed by Lay were an abuse of the legal system. Unfortunately, Martin Lee, I think it's Lee, not Leah, but whatever, did not follow the safe harbor requirements outlined in Rule 11C2. To be sure, this does not mean Lay was protected from all sanctions. The district court should have imposed sanctions pursuant to Rule 11C3, awarded costs through 28 U.S.C. 1927, or used its inherent powers to impose sanctions. But because none of these alternative avenues were pursued, we are left with no other choice but to reverse the district court's sanctioned award. I would like to see how the judge ruled on that when they did their final ruling. Did they say that they were awarding these under Rule 11? And that's the rule they cited to in awarding these things. Because that's not what we have here in the Owens case. So I would like to see that, since I'm not familiar with that. If I had access to it, that would be great, but I don't. Is that how it was? Did they do it in pursuant to that rule? Because that is not identical to Clayton's case, where he's saying that she used Rule 26 when she did not cite to Rule 26 in issuing the attorney's fees. And no other sanctions or anything were added. It was just attorney's fees. The problem, of course, is that these statements are pure obiter dicta because the lower court did not impose sua sponte sanctions, but rather just granted Mr. Lee's motion for Rule 11 sanctions. Well, see, that's not what happened here in this case, David. The Court of Appeals merely assumed in passing without actually deciding that an award under any other authority might have been legally proper. But again, the exact issue was considered and rejected by the Ninth Circuit Court in Ratcliffe, where the court held a sua sponte award was not proper. In the face of these adverse authorities, Clayton offers a wistful warning. This court should not assign a talismanic quality to Rule 26 because doing so would have undesirable consequences. Under Laura's interpretation, the offending filer would have an unconditional right to opt out of litigation no matter how egregious their conduct or unreasonable their position if the opponent invokes the rule. However, if a party never invokes Rule 26, instead of pleading a request for attorney's fees under ARS 25-324 or other applicable statutes, then the safe harbor opportunity would never materialize. He says, okay, right, so what's wrong with that? Well, you don't think there's anything wrong with it because your client would get to walk off scot-free. But if somebody was doing this to you, you would absolutely not be saying, what's wrong with that? So what? Okay. You don't think this is right, and if it was being done to you, you wouldn't like it. Clayton sees these scenarios as conflicting, but clearly they are not. Any litigant who thinks the opposing party has violated Rule 11/26 has a choice. They can A, send an immediate notice threatening sanctions and hope the opposing party responds by dismissing the case, as Laura did here. Yeah, except for she didn't do it in the time that she should have. Or B, they can wait, litigate the case, and then seek fees under any available authority. Here, Clayton took neither approach, at least not exactly. Instead, he allowed the case to languish for over 4 months to the point it was set for administrative dismissal due to inactivity. I think it's because she was needing to do something and he had already put in his stuff. It was her turn to respond to things. And so when he found out nothing was happening, he's like, oh, I guess I better respond now, is how I kind of see the way things went. Then the case was already functionally dead. He retained counsel who threatened Laura with retroactive sanctions, a la Carnici. In response, Laura immediately moved to drop her petition, which by then was moot, a la Carnici. Clayton inexplicably opposed this, putting Laura in a position where she was given no chance to remedy the sanctionable conduct and avoid the sanction. And he says, a la Carnici again. This is where the heart of the procedural error lies. Had the law been followed correctly, the trial court would have granted Laura's dismissal request on December 28, 2023, because Rule 26CB gave her absolute right to invoke the safe harbor in response to a threat. Not on 28th. That was well past the safe harbor period. The ship had already left the harbor. Because Rule 26B gave her the absolute right to invoke the safe harbor in response to a threat, then would have terminated the case before either party incurred any significant fees. So now you're saying significant fees, not no fees. That outcome is exactly the result Rule 26 was written to achieve, but which was not achieved here, solely based on Clayton's dilatory invocation of the rule and the trial court's erroneous refusal to apply the rule correctly. Instead of granting Laura the safe harbor to which she was entitled, the trial judge erred by rejecting Laura's attempt to drop her petition. The court then further erred by forcing Laura to involuntarily litigate the case, ultimately ordering her to pay $150,000 in fees for acting unreasonably by A, filing the case without sufficient basis, and B, by continuing to litigate the case against her will. Here, there is nothing unfair or inappropriate about a rule which gives a party accused of misconduct the option, indeed the unconditional right, to stop that conduct. That is exactly what the rule was intended to encourage. Rules 11/26 were adopted for the express purpose of permitting litigants to drop claims without facing sanctions, no matter how egregious the violations. The problem here, aside from the fact that Clayton could and should have invoked Rule 26 4 months earlier, is the trial court refused to allow Laura to take the safe harbor. Well, it was past the 10 days. The court then punished Laura severely for continuing to litigate the case, even though she was forced to do so against her will. Well, she didn't need to act like a child and doctor and lie about a whole bunch of stuff in the meanwhile, because she wouldn't have had to deal with these freaking sanctions or attorney's fees if she would have acted like a grown adult woman and didn't lie and manipulate. But instead, she acted like a toddler, threw a fit, and played arts and crafts. This is exactly the wasteful, absurd result Rule 26 was designed to prevent. The trials court refusal to grant Laura the safe harbor was a pure error of law. That error standing alone requires reversal of the judgment below. The court should therefore remand with instructions to dismiss the case with prejudice without regard to any other issues. So that was issue 1. Now we're going to go into issue 2. Structural error. Let's assume this court rejects Laura's Rule 26 arguments. Further assume the court finds the safe harbor of Rule 26 does not affect the trial's ability to award fees under other authorities. Does that mean the $150,000 judgment in Clayton's favor may be affirmed? Absolutely not, is what he says. Laura alleges the trial judge violated her constitutional right to due process by performing a secret, undisclosed investigation into the facts. If you need to know about this, I have done a video, and it is called Does Judge Mata Have Permission to do this? This result in the court making a key finding that Planned Parenthood is closed on Sunday, which was supported by no admitted trial evidence. Laura argues these facts constitute structural error because they prove the trial judge was biased. I don't see how looking at hours or finding hours is bias. Because what if it proved that it was open on Sunday? And that part would have been in Laura's favor. Would she still be biased then? Or is it because the results didn't back Laura's story, so now that makes her biased? Which is not how biases work. As shown by the judge's decision to engage in unlawful conduct which violated Laura's right to due process, Laura further claims the only available remedy for this violation is automatic reversal of the judgment and a new trial before a different judge. Bearing in mind, Laura also maintains there is nothing left to try here. Understandably, Clayton challenges each point except the main one that the trial court's finding about Planned Parenthood business hours was not supported by any admitted trial evidence. Trial evidence. But Gingras' blogs were in motions, and if she saw comments after trial, because she went through and looked at different evidences and things and links that were sent to her, and she saw it and she just put it to the wrong thing, is she actually in the wrong? But she said Clayton calls this a harmless error, and then he argued the issue of Planned Parenthood's business hours, yeah, as he should, was cumulative and thus unimportant. He also suggested that even though the trial court never claimed it took judicial notice of Planned Parenthood's business hours, it could hypothetically have done so. I guess it could have. I don't know. Like I had put on a post today, I like to think that we don't live in a hypothetical world as far as this case goes. Clayton's people who are on his side because of it being the right thing to do, I think lives in a factual state and not a hypothetical one. And we don't need to worry about hypotheticals because there is enough here. We don't need extra hypotheticals. Structural error applies in family court. To begin, Clayton argues structural error does not apply in Arizona family courts because counsel cannot find any example of Arizona courts applying structural error analysis in a family law case. Laura agrees this is a question of first impression. At least in family court. See footnote 4. The question of whether structural error might apply in family court or in civil vexatious litigant proceeding arising from divorce case was briefly mentioned in Contreras or Treyas, whatever, appellate case from 2024. So very, very new appellate case. And then this court held the issue was waived since it was raised for the first time on appeal, so the question was not decided. Well, this one is kind of similar just because it is the first time that this Planned Parenthood hours have come up is on appeal. And well, he did try to get a new trial court, so maybe not, but this stuff wasn't known and nobody knew about it until after the final ruling came out. So that might be a different circumstances than this case, because if sounds like that other case, it could have been known prior to the end of it, and then they just decided at the end of it that they were going to bring something up about it, and they waived their rights because there was no objection or something on the issue when it happened. And you got to use those objections to preserve your appellate arguments. And for good reason, serious acts of judicial misconduct, such as occurred in this case, are thankfully rare in Arizona, especially in family court. Sir, you don't know anything about family court. Like, you don't practice in family court. But as this case shows, judicial misconduct does happen, and as Laura explained in her opening brief and other pleadings, many other courts agree. Any independent factual investigation by a trial judge is unlawful. But there's also a Supreme Court ruling that says not really. So that would be interesting. Shows bias, and it constitutes structural error as a matter of law. The U.S. Supreme Court has limited structural errors to the following: the complete denial of counsel, a biased trial judge, State v. Torres, Arizona 2004, and also State v. West, Ohio 2022. The presence of a biased judge on the bench is, of course, a paradigmatic example of structural constitutional error, which, if shown, requires reversal without resort to harmless error analysis, citing extensive authorities. You want to see a biased judge? Go watch the RICO trial for, I don't know if it was the YNW Melly. I think it was YNW Melly case. That happened in Atlanta, I believe. It was in Georgia. And it was the RICO one. I don't think that was Young Thugs. I think that was YNW Melly. That was a biased judge, or even Judge Grudge in the What the Hell's case. That's a biased judge. That is not what we have here as far as Judge Mata goes. Laura does not dispute that it appears no published or unpublished Arizona opinions have considered the question of whether structural error analysis applies in family court. Clayton suggests otherwise, claiming something similar occurred in Black v. Black, an Arizona 1977 case, which he calls extremely instructive. To the point, the relevance of Black is difficult to overstate. There are two reasons why Black is not remotely helpful. First, Black was decided in 1977, nearly 50 years ago, more than a decade before the United States Supreme Court adopted the modern structural error doctrine, which is, of course, binding law in Arizona. Structural error itself is a function of the Due Process Clause, and while courts have always wrestled with the remedy for specific types and degrees of due process violations, the modern-day application of structural error was not fully embraced until whatever that case is from 1991, and refined later in cases such as Netter v. United States, 1999. That is why Black limited its discussion to harmless error and never mentioned structural error, because the modern rule did not exist, at least not in the current form. When Black was decided, see State v. Ring, Arizona 2003, discussing origins of structural error and citing that other case, clearly in light of more recent decisions applying structural error analysis to a judicial misconduct, whether Black remains valid law is questionable at best. The second reason Black is not helpful is it appears Clayton misstates the fact of the case. Specifically, Black involved a petition to change custody of two minor children. At some point, the trial court conducted an off-the-record interview with the Black children. This was done without a stipulation by the parties. Based on the interview, the court changed custody, finding, among other things, both children have expressed the opinion to the court that they do not want to continue living with their mother. Black, emphasis in original. Clayton says Black is thus analogous in Black, just as Laura alleges occurred below. The trial judge independently investigated material facts without notice to the parties. The parties only learned about the interview via one finding in the final judgment. That is kind of what happened here. They didn't learn about this until the final judgment came out. But that case with the interviewing the minor children without the parents' knowledge, absolutely not okay. So it says, not so fast. Clayton appears to have invented these facts from thin air. Nothing in Black says the trial judge investigated material facts without notice to the parties, nor does this case say the parties only learned of the interview by reading the final judgment. Rather, the case merely says the parties did not stipulate to the interview occurring, not that the parents were unaware of it. See footnote 5. Black does not explain specific circumstances of how the interview took place, but children were just 6 and 8. Presumably, a family court judge would not have access to interview such young children without at least one parent's direct involvement. And nothing in the case suggests the interview was done ex parte without the other parent's knowledge, which would have been a separate problem. The case simply says the interview was not stipulated to by both parties. So basically he's saying here is that the mom and the dad didn't stipulate, but maybe just the mom stipulated or just the dad. So it could have been one, but it wasn't both of them. But it also could mean that neither party. It doesn't say that, but it just says both, which, um, depending on the custodial and legalities, if you don't have legal custody, which is really hard to lose, like legal custody, you can have custody of a child, like physically, but the other parent still has legal custody as well, at least part of it. But legal custody, if you lose legal custody, that means that you don't get a say in anything about your kid. The other parent does not have to talk to you about anything before they do anything. Um, that's where joint custody is usually what happens. Even though one usually has them most of the time, it's still considered joint because you talk to each other about the important things. But we don't know the case of that, but I do get what he's saying right here. It wasn't that none of the parents knew. It's possible. But unlike in Black, the trial judge's horrific misconduct in this case is not subject to harmless error review. The misconduct was structural in every sense because it completely deprived Laura of her fundamental rights to a fair hearing before an unbiased judge. What was Laura gonna say? Those aren't right, or they were when I went? Like it wasn't gonna change anything. That's why it's harmless. Like nothing that would have happened or come out of this and even confronting Laura would have changed anything. She would have changed the date. She would have said, "Oh, they were when I went. Those people aren't right. Their hours aren't always what they are online." Like it just would have gone nowhere. Like this would have changed nothing. While this question is a matter of first impression for Arizona, the issue is hardly novel. Multiple courts in other states agree structural error applies in family court. For example, in the particular case, which is Kentucky 2017, the Supreme Court of Kentucky considered the question of structural error in family court case, where the trial judge independently investigated the criminal history of a party. In an extensive and well-reasoned opinion, the court held the family court's independent secret investigation of a single fact constituted a structural error requiring automatic reversal. Indeed, in that, Kentucky Supreme Court rejected many of the same arguments Clayton presents here, specifically in that particular case, the Marches, during a hearing on a petition of domestic violence restraining order. The trial judge called a recess, then asked the respondent to provide his social security number, which he reluctantly did. When the hearing resumed, the judge informed the respondent he had a criminal charge from another jurisdiction. As the Kentucky Supreme Court opinion tersely explains, at no time did the trial court judge disclose the source of her knowledge of the alleged Virginia Beach assault conviction, or describe the legal grounds upon which the information was interjected to the DVO hearing, nor did the judge give Marchese an opportunity to address the issue. Emphasis added, Supreme Court unanimously held the judge's misconduct constituted structural error. Before we get to that, that is a main issue. And the fact that he had a criminal charge in another jurisdiction is the reason for the DVRO, and she was like, yeah, I believe you. This Planned Parenthood hours is not a sufficient fact in determining that Laura is a liar. That's where all these cases that you continue to cite, this is not the primary reason for her decision, whereas this stuff is primary reasons for these things being done. That's where you're not grasping and understanding, Gingras. Continuing on, we conclude the trial judge undertaking to obtain and use evidence, extrajudicial information relating to a party in a case caused her disqualifications from proceeding further as the presiding judge in this matter. Her failure to recuse at that point was structural error, undermining the integrity of the resulting DVO. Because structural error supersedes harmless error review, we need not review the finding of the Court of Appeals that the error was harmless. Here it wasn't, and when you're doing these DVOs, domestic violence restraining orders, DVROs, or whatever you want to call them, make sure you're doing it right, because we need those things to be held up if they're proper. Unless it is an Amber Heard or a Laura Owens coming in and lying. But the thing is even if these people, even if Clayton was a really, really, really bad thing, like he was a bad guy altogether, what was being done to him still wouldn't have been right. People may think, oh, he's a bad guy, he deserves whatever comes to him, but really it still wouldn't be right. Like Clayton could be a horrible guy and Laura would still be in the wrong. They would just be two shitty people instead of just one shitty person. Notably, the court reached the conclusion, even though the source of the trial judge research was unknown, because as in this case, the judge failed to explain where the extrajudicial information came from. Here, like in the Marchese case, the trial judge never disclosed the fact of her investigation, nor did she ever disclose the source of the knowledge gained. Clayton suggests this is no big deal because the trial court could have taken judicial notice of Planned Parenthood's business hours, contrary to an ABA formal opinion which says exactly the opposite. Now, I don't think that you could have taken judicial notice on something if you didn't state you took judicial notice of it and let the parties know. I do agree with that. The Marchese court rejected that argument because the judge failed to disclose the source of the information upon which she relied. The record fails to support that the information was obtained from a properly authenticated public record. The use of the information acquired by the judge from an unidentified source is simply an inappropriate use of extrajudicial evidence to guide a ruling in a matter. Emphasis added. Many other courts concurred with the Marchese because structural error derives from the due process clause. It applies in family law where due process is mandatory. The marriage of Carlson, which is a California appellate case in 2008, rejecting argument structural error does not exist in family court, and concluding whether we call this error structural or not is inconsequential. The failure to accord a party litigant his constitutional rights to due process is reversible per se, and not subject to the harmless error doctrine. In re Dependency of A&G, Washington appellate from 2020, structural error applies in family court. Ryan v. Ryan, a Michigan appellate 2004 case, binding structural error in family law case where child filed complaint for divorce from parents. Another case is cited from Wisconsin appellate in 2008. Structural error applies in family court. So he's found these things in other states. It's just not been in Arizona. Clearly aware a finding of structural error requires reversal, Clayton pleads for this court to adopt harmless error standard for judicial misconduct. He asserts under that standard, Laura must still demonstrate prejudice, which he claims she has failed to do. To support his argument, Clayton cites two cases previously mentioned by Laura. A Kansas appellate 2020 and another one that is also in Kansas appellate 2018. Clayton claims both cases espouse harmless error review that is nearly identical to Arizona's approach. Clayton's argument is half right and all wrong, which It makes no sense because you can't be, it would be half right and half wrong, or all right and all wrong, or all the way wrong, none of the right. So, whatever. In both cases, the appellate courts did suggest a showing of prejudice is necessary, as would be true in harmless error review. So Clayton got that part right. Okay. So then he's not all wrong. Contradictory. But in both cases, the court held an ex parte investigation by a judge is always unlawful and prejudicial if used to decide any fact in the case. But it wasn't used to decide everything. Like all the other stuff was that. She shouldn't have cited it. That was her problem. There was plenty more to cite other than that. Even with that section of Clayton's case regarding Planned Parenthood, the hours didn't need to be mentioned. There was plenty other things in that that would go towards your decision. An improper ex parte investigation by a district court is prejudicial when it bases its ruling, even in part, on the investigation and a fact that inferred from that investigation. It can be something that is not okay. Like, she can get in trouble for it. I don't think that Clayton should be punished for it. Like, that's what I don't think. Because a judge is misbehaving on certain things, why does Clayton have to take punishment for that? That's one thing I don't like about any of this, is that Laura could win because of something that she put in there. Like, I don't like that. Like, I think that the judge can get in trouble, but Laura has still fucked up enough to still owe attorney's fees. That's how I think that should go, maybe. Hey, don't do independent research. But again, I don't think she fully did independent research. We find the district court's judicial misconduct prejudiced Mother's substantial rights by depriving her the right to procedural due process. And that is a Kansas unpublished case from 2018 and 2020. Those cases he mentioned before. In short, the cases Clayton cites do not help his position. They destroy his only argument, that a showing of separate prejudice still must be made in a case involved an unlawful judicial investigation into the facts. That is wrong. Those cases all say the same thing. Independent judicial investigation is per se prejudicial and requires reversal under the U.S. Supreme Court modern structural standard error jurisprudence. Here, there is no dispute the trial court made a factual finding that Planned Parenthood is closed on Sunday. That was not supported by any trial evidence. There is no dispute that this issue was not discussed or mentioned at trial, but it was discussed in social media posts after trial. The only reasonable conclusion is the trial judge looked at social media after the trial ended, and she then based her factual finding on those posts. The misconduct is per se structural error of the most obvious kind. Assuming this court agrees, automatic reversal of the judgment is mandatory without regard to prejudice. So now he's going into C, issues 3 and 4. The court erred by awarding fees awarded under other authority. If Rule 26 is the centerpiece of Laura's argument, Clayton's centerpiece is this. Ignoring Rule 26, the court still could have awarded fees under other authority like ARS 25-324, 415, and 809. That argument was superficial appeal, but it suffers from multiple fatal flaws. Flaw number 1. Clayton never moved for fees under any authority. He cites. Yes, he does. as far back as his first filing in this case on August 21st, 2023. I will link it in the description box. I'm trying to do better about it, but the way to go about posting, sometimes I forget. But I will have it posted there. The only fee-related motion Clayton ever filed was his Rule 26 motion for sanctions, but he put it at the end of all his other motions, just like you did in your motions. And as explained above, the rules of family law procedure require parties seeking relief to bring a motion for relief. See Arizona Rules Family Law Procedure 35A1, explaining a party must request a court order in pending action by motion unless otherwise provided by these rules. No motion, no fees, end of discussion. Law 2. Even if the trial court did not sanction Laura under Rule 26, she was entitled to a safe harbor of Rule 26C2B by withdrawing her petition after Clayton's counsel threatened her. Laura's unambiguous attempt to do exactly that when she moved to dismiss her petition on December 28, 2023. After the 10-day safe harbor. But they're going to say it's not after, it's actually before, because he didn't file the motion 26 as a separate thing until after she already tried to dismiss the case. They filed for it after she wanted to dismiss, is how he's looking at it, even though he mentioned it in previous filings before the December 28th date. The trial court erred by refusing to permit Laura to withdraw a petition. Laura had absolute right under Rule 26C2B to do exactly that. At the time, Clayton had not incurred $150,000 in fees, and any fees he did incur in late December were unnecessary and unreasonable because simple phone call from Clayton's counsel would have revealed Laura was no longer pregnant, and thus there was no need for Clayton to defend the paternity allegations. This line right here pisses me right the fuck off. Because Clayton's counsel should not have to call Laura every single day or once a week or once a month to be like, hey, bitch, you still pregnant? Like, that is absurd. Because it is Laura's responsibility to let people know. And she decided not to until possibly many, many months later, if you go by July, and the blood clot situation, or her period blood, which I believe it is. Sorry for the TMI. Or even if we go by the later November, mid-November date, she waited a whole month and a half for that. And so, yeah. No, it's not Clayton's job to find out if she's still pregnant. It is her job to let people know. Pick up the phone. Nobody wants to talk to your client. Everything with your client needs to be written in black and white because she can't be trusted. We want no oral arguments with her, thank you. Oral is how we got into this mess. It's not how we're getting out of it. I digress. To be clear, if the family court had complied with Rule 26C2B and allowed Laura to withdraw her petition in late December, does that mean Clayton could not have sought fees under any other authority? No, of course not. If there was a factual basis for fees under other authority, Clayton could have brought a motion for fees at that time. He simply chose not to do so. This is where Clayton's position is so deeply confused, so let's try to finally put this to bed. Laura is not claiming Rule 26 is the only authority by which fees/sanctions may be awarded. By extension, Laura is not saying a person who violates Rule 26 could never be ordered to pay fees based on other authority. Rather, Laura is simply saying that to award fees or sanctions under other authority, there must be a separate factual basis for such an award beyond just the Rule 26 violation, because conduct in violation of Rule 26 must be resolved under the provisions of Rule 26. Why does Title 25 stuff have to be resolved under Rule 26? It's Title 25. It's something completely separate. Anybody want to explain that? Gingras? And Laura doesn't simply state this crap. I know he's speaking on behalf of her, but Laura doesn't know how to get her thumb out of her ass, so she doesn't know anything about this. She's just like, yeah, whatever you say, Gingras. Whatever you say. Put differently, conduct that violates some other rule or supports a fee award under other statute aside from Rule 26 can always be addressed by the other rule/law. But a violation of Rule 26 resolved by invoking the rule's safe harbor is not punishable under other authority without any other basis. Clayton's deep confusion on this point is best demonstrated by his discussion of Holgate v. Baldwin. 9th Circuit 2005. It's on page 31 of his brief. In Holgate, the 9th Circuit reversed an award of Rule 11 sanctions because the moving party did not comply with Rule 11. The 9th Circuit then briefly noted that the trial court could have awarded sanctions against a different party under different authority, 28 U.S.C., whatever. However, such an award was not made because the trial court did not find bad faith as to the other party. Well, the trial court did here find bad faith. Clayton suggested this supports his position because in this case, the trial court did make a finding of bad faith. Problem solved, right? Gingras says wrong because Clayton misunderstands the federal law referenced in Holgate. The federal statute mentioned in Holgate, 28 U.S.C. 1927, is not analogous to nor coextensive with Rule 11. Rather, 1927 addresses something completely different, vexatious conduct by an attorney. So he's saying that one has to do with vexatious conduct by an attorney, not a party. And he puts in here, cites any attorney or other person admitted to conduct cases in any court of the United States or any territory thereof who multiplies the proceedings in any case unreasonably and vexatious may be required by the court to satisfy personally the excess cost, expenses, and attorney's fees reasonably incurred because of such conduct. Any attorney or other person. But let's see what he says. Rule 11 and 1927 deal with totally different things. Rule 11 is limited to meritless pleadings, not litigation conduct, while 1927 is focused on litigation conduct, which unnecessarily multiplies the proceedings. Thus, a discrete single violation of Rule 11 cannot be punished under 1927 unless the violator also did something else to unreasonably multiply the proceedings. Well, Laura did multiple things. I don't know if that's the same thing. Contrary to Clayton's argument, Holgate does not stand for the idea that a court can use 1927 as an alternate means to punish the same act which violated Rule 11. Rather, the Holgate court explained that if a person violates Rule 11 and also separately engages in a different conduct that violates 1927, then a failed attempt to invoke Rule 11 does not mean the violator could not be punished under 1927. But in Holgate, the trial court did not find any such vexatious conduct occurred, therefore no award of sanctions under 1927 was made. Well, that's the thing. The trial court found stuff here and maybe it didn't in Holgate. This is the crux of the problem. When Laura moved to dismiss her petition on the 28th of December 2023, even if we accept Clayton's allegation that Laura violated Rule 26 by filing a petition she knew was groundless, at that time, she had not engaged in any unreasonable litigation conduct sufficient to support an award of fees under other authority. It is if she filed this knowing she was never pregnant. If she filed this knowing she wasn't ever pregnant at all by Clayton or anyone else, she engaged in unreasonable litigation from August 1st on. August 1st to December 28th, she did. And you don't just get to dip out and just do that to people. You just can't. She's not engaged in unreasonable litigation conduct sufficient to support an award at fees of other authority. On the contrary, from August 1st, when the case began, to the time Laura learned her pregnancy had failed in mid-November. That's you thinking she had a failed pregnancy in mid-November. But if she had a failed pregnancy in July, or she was never pregnant, then this argument doesn't hold up, which is Clayton's point. Clayton was not represented by counsel in a paternity case, and he incurred no fees defending that action. All that happened was Clayton took a DNA test, which was inconclusive. It was not inconclusive. It gave a result. The least result that they could ever give, because they can't ever say it's 100% yours or it's 100% not yours, or there's 100% no baby. I mean, they can say there's they can't even say 100% there's a baby. Like it always has to be, there always has to be a margin of error. Nothing can be 100% unless you're talking to Owens. Little to no fetal DNA. And it's not just a test, it was multiple tests. And shortly thereafter, Laura learned about the pregnancy had failed, and she basically abandoned the case. That's it. Well, you don't get to just abandon cases. I don't think you should be allowed to abandon them. Thus, the case is likely that Holgate, insofar as the only basis the trial court had to sanction Laura in late December, was for violating Rule 26 at the time her petition was filed. But as to the period between August 1st and December 28th, Clayton does not allege Laura did anything to justify any award of fees. Yes, he does. She was never pregnant. There you go. Much less $150,000 in fees under any authority other than Rule 26. Even if Laura did something improper during that time period, it did not cause Clayton to incur any additional fees because he was pro se. Was one order compelling discovery, dated April 4th, 2024. This order required Laura to produce 5 categories of information, but there is not a shred of evidence in the record showing that Laura failed to comply with this order. Yes, there is. She was told on camera. She is signing this HIPAA form, and she is handing over the information to any and all doctors she has seen in regards to this case, and that they are going to be allowed to get records from 2020 on, which meant from Greg's case to now, I believe is what it was. So stop lying there. Instead, what Clayton seems to believe is that Laura had a general duty to disclose information under Rule 49. Yeah. She has a duty to disclose anything that has to do with this case and her being pregnant or not, and Clayton being the father or not. She had a duty. And because she changed her story about the location of the Planned Parenthood location she visited, that violated Rule 49 because Clayton believes Rule 49 requires Laura to disclose the specific information prior to trial. In what case, what lawsuit in the history of lawsuits is it okay to omit information, exculpatory information, in a civil lawsuit, a family lawsuit, or family case, or in a criminal case? When is it ever okay not to hand over all relevant information? Are you freaking kidding me? Clayton's argument fails in multiple ways. First, even assuming Laura was required to disclose something under Rule 49, the failure to do so is not itself punishable with fees under 25-415. Again, by its own terms, 25-415A-3 only permits fee awards when a litigant violates a court order compelling disclosure or discovery. She violated a court order, and she violated the compelling discovery disclosure because there was motions to compel discovery and to disclose information. Like, are you freaking kidding me? This is just ridiculous. Let's see here. He says, let's see. Okay, he says A3, a court of competent jurisdiction has not entered or approved an order concerning the child's custody within 1 year before the person filed the petition, unless there's reason to believe. And he says, pending dissolution. Sections. Let's see what Rule 49 is. Requires party in a family law case to share information and documents. The rule aims to ensure fairness and transparency by helping both parties understand the case. When initial disclosures are due within 40 days of the first response petition, additional or amended disclosures are due within 30 days of the discovery of the new information. She had this information way more than 30 days before she handed it over. Like, are you kidding me? Let's see. What happens if you don't hand it over? Disclosure statements falls on both parties. What information do I have to disclose? There's a list of things that need to be disclosed under Rule 49. Healthcare records and insurance information for children, educational expenses and school records, documentations. Failure to disclose can lead to court sanctions. The court may impose various sanctions on a party that fails to disclose required information. They can range from monetary fines to more severe penalties such as contempt of court, which may include imprisonment. So maybe instead of a sanction, Judge Mata should have imprisoned her. Damaged credibility. Attorneys' fees and costs. The non-compliant party may also be ordered to pay the fees and court costs incurred by the other party in discovery for the non-disclosure. Plain and simple, David. Like, I'm not an attorney and I understand this. But you want to use word games and try to manipulate a way that says this is not the thing. Oh, she did not violate any disclosure duty under Rule 49. Nothing in that rule required her to disclose information about specific Planned Parenthood location she visited. Clayton could have asked for that information in an interrogatory under Rule 60, but never did. He asked her about these things, I believe, in her deposition. It was also brought up in a hearing. Maybe you should go to Snitchel Ninja's channel and watch that. She's got all the videos there for you, David. You can watch her videos and learn about the case because you apparently don't know it. Oh, it's not punishable with fees. Yeah, it is. She could have just gone to jail for contempt of court. Judge Mata didn't do that, so I guess she's not that biased. Rule 49I does, of course, require parties to disclose the names, addresses, and telephone numbers of any witnesses whom the disclosing party expects to call at trial. But Laura did not plan to call any witnesses from Planned Parenthood at trial. Clayton did. So Clayton was supposed to just figure out and call all the Planned Parenthoods in all of America to figure out where Laura might have gone. And guess what? They're not going to give him that information because that is where the anonymity comes in, not from using fake names. It means that your information is not going to be given out to anybody else. So let's not try, well, because he wanted to call somebody, he should have figured out which one it was. No, that's not his job. She knew what she was supposed to do and she fucked up. Quit trying to say she didn't. Like, you can defend certain things. I'll let you defend the independent investigation. Because that one, you might be somewhat right on. That it shouldn't have happened. I think she had reason to figure it out. I think she credited it to the wrong person. She did have errors in her final judgment, such as the date and things like that. But you and I will have no problem with any person defending anybody in a criminal trial or whatever on certain things. But what I do not like and think you should be allowed to do is get up here and blatantly lie. This is not okay. This is not a misunderstanding of the facts. You're trying to say that she didn't have to hand over any of that. She didn't need to tell anybody about Dr. McCool's information, Dr. Higley's. Like, she didn't have to disclose any of that stuff because she wasn't going to call any of those doctors. Are you freaking kidding me? It's like the murder person be like, well, I wasn't going to call the police officer, so I didn't need to give it. I wasn't going to call the witness that was there and saw the murder. I'm not just going to hand that information over. I mean, they find that stuff out, but this is not that. He's not a police officer. He can't get people to do those things. He doesn't have a geotag on her. Like, come on. This is ridiculous. The fact that Clayton wanted to call a witness did not require Laura to disclose that information under Rule 49. Nothing else in Rule 49 required Laura to disclose the type of information which Clayton claims was omitted. But again, fees cannot be awarded under 25-415A3 for a disclosure violation under Rule 49. Only the violation of discovery order, which did not occur here. Yeah, it did. She did violate discovery orders. D, issue 5. Laura is entitled to fees. No, she's not, but sure. You're going to argue it. You have the right to argue it. Very little of Clayton's fee argument requires any response except for this. Clayton argues dismissal of Laura's petition would have been improper because his claims, including a determination about whether Laura was ever pregnant by him in the first place, still needed to be adjudicated. This argument weighs heavily in favor of Laura's request for fees. Here's why. The question of whether Laura was ever pregnant by Clayton in the first place is clearly outside the limited scope of family court's jurisdiction. No, it's not. He has the right to know if you are pregnant with his babies. Which meant, were you pregnant? The family court can decide that stuff. This allegation is, if anything, an element of a civil abuse. No, it is not, but okay. Just let women falsely accuse people of bearing their children. No. It's abuse of the process and malicious prosecution claim. In other words, Clayton's description of his claims show the only claim he was seeking to resolve is one he knew or should have known. The family court had no jurisdiction to decide. Nothing in Title 25 permits a family court to adjudicate civil tort claims like this. That fact alone and Clayton's otherwise unreasonable position in this appeal warrant an award of fees to Laura. Conclusion: this court should reverse the trial court's judgment in its entirety, award Laura her appellate fees and costs, and reprimand this matter with instructions to dismiss the case with prejudice. Dated January 3rd, 2025. Gingras' Law Office, David Gingras, attorney for petitioner appellant Laura Owens. And he sent a certificate of compliance. That he was granted on January 29th, leave to file an over-lengthy reply. And then his certificate of service that he provided it to Woodnock's Law Office for Clayton. So that is his reply and response to the appellate brief. So, quote of the day, and Owens needs to hear this and anybody else. If you stop telling lies about me, I'll stop telling the truth about you. So if Owens would quit lying and Gingras would quit lying, we could stop having to tell the truth and throw it in your face. And just to tell you, telling the truth on you is not harassment. It's just not. But stop telling lies and people won't have to stop telling the truth about you. We got to call out your lies. Liars deserve to be called out. How else are your pants going to be on fire? That is it for this video. Please hit that like button, subscribed, and I will see you guys in the next one. Bye.